Welcome to the GovComms podcast, bringing you the latest insights and innovations from experts and thought leaders around the globe in government communication. Now, here is your host, David Pembroke.
Hello, ladies and gentlemen, and welcome to GovComms, the podcast that examines the practice of content communication in government and the public sector. My name's David Pembroke, and thank you once again for joining me. Today, we are once again going back in time, back into the archives of the old In Transition podcast, way back to 2015, where we talked to Shaun Creighton, a commercial lawyer and specialist with expertise in the identification, protection, and commercialisation of intellectual property rights. But indeed, what we look at really is why we need to get lawyers involved in our content communication programs and why it's so important to bring them along for the ride from the beginning and not the end. You see, content communication, the goal of it and the purpose of it is to create those strategic and measurable content communication programs that rely on the curation of valuable, relevant and consistent content distributed through both online and offline channels in order to achieve that desired citizen or stakeholder action. Now, there's quite a bit that goes into that, and there's quite a bit that the lawyers need to understand in terms of the content that you're creating, how you're distributing, where liabilities might lie. And one of the issues that I've found over the years is that often what happens is that content communication programs are built, but then they don't go anywhere because the lawyers start to have a look at them and then, things start to get legal, which is the last thing that you want things to do. So in my conversation with Shaun, who is a fantastic guy, former Olympian, by the way, not known by many, but he was a champion Australian distance runner and recently set the Australian record. It may have in fact been the world record for a marathon over the age of 50. Incredible guy, wonderful guy, a great athlete, but even clever lawyer. He's out at Moolis Legal, currently a partner out there where he does lead their intellectual property and government procurement practice. So anyway, this is a great conversation. I've always enjoyed talking to Shaun, and I hope you enjoy my conversation with Shaun Creighton. Let's think about it. Let's go to the idea of a life of a lawyer, because I think a lot of communication people really don't understand the law, nor do they understand lawyers, because we're in our world, you're in your world. So what's it like to be a lawyer?
Someone asked me the other day, do you like being a lawyer? And I said, well, actually, I do. And they got a shock because most people ask, do you like being a lawyer? The answer is no, I wish I did something else. But I enjoy working, particularly in creative industries, and working with people like yourself, David. So an intellectual property lawyer, one of the things which is what my specialisation is, you get to work with a lot of creative people because there's a lot of creative materials which are developed and a lot of interesting legal issues which arise from it. So that's where I get my kicks being a lawyer than in working with a lot of interesting people who are a lot smarter and more creative than me. And interesting, I did a personality test a couple of years ago, and they said that I fitted in the category which I think is perfect for an IP lawyer. I wasn't your normal dot the I's and cross the T's lawyer, which you still have to do that. I was someone who, my personality type fitted in well with working with creative people to help take their ideas and their concepts, essentially commercialise them and manage the risks and all those sort of things, rather than being like a litigator, that sort of thing. So it was actually worked in well with what I was doing. I thought, that reinforces why I'm doing what I do and why I enjoy doing what I do.
But you have that intellectual property side, which is that part of it, but
yes.
You're also senior legal counsel for a very important Australian federal government agency.
Yes, that's right. So a lot of IP works in a lot of complex IT procurements, for example, which government agencies, including Air Services Australia, have got complex radar systems and IT infrastructure. A lot of IT disputes and a lot of IT issues and the commercial issues around that have an IP focus, and the reason for that is that a lot of the a lot of IT, the legal value is in, for example, the source code. Source in the computer programs, the source code is protected at law under the copyright laws. So copyright is one of the backbones of IP. So that's how most IP lawyers also do IT procurement work. So that's how they work together.
But do you have a broader remit than that at Air Services Australia?
I do, yes. I do general corporate commercial, but I do a lot of IP, IT focus work, which is what I also do so I've got a dual hat. I've got a hat as the Senior Legal Counsel at Air Services Australia and the second hat of running a small boutique IP firm. But in both roles we do broad corporate commercial, but with a very strong IP focus.
Okay, so let's just focus, if we might, on your work in a federal government agency, because it's an important role. It's a big job. Certainly relied upon by the senior executive to be able to give them advice. Just before we get into that discussion, can you describe what a typical day might look like for a lawyer in that sort of environment?
In the government environment, there's a lot of procurement-related activities.
Okay.
So you're actually looking at the procurement documentation before it goes to market. You're drafting the terms and conditions that attach to the tender. You're looking at the legal responses for a procurement activity, and then you're entering into negotiations with a preferred respondent. But you're also advising the business more generally in relation to why we need a contract, why you can't just shake hands with the supplier and say, yep, let's get on with it. And so I guess there's an education piece as well, particularly in relation to who owns the IP and why things in a contract need to be covered, particularly in relation to IP. Who owns it, and that's often a sticking point. And then once you've identified and clarified who owns it, what's the scope of the licence granted to the other party by the one who doesn't own it? So that a right to use and for how long and for what purposes and what you'll get paid and all those sort of things. And that's important to document and clarify up front, whether it's a government agency or department or a sole trader or an SME.
So apart from the leadership looking to you to be competent in your work, what other sorts of advice are they looking for from you around some of the risk issues that are involved?
A lot of the risk issues turn on if a typical one is a limitation on liability or an indemnity. So an indemnity is where you promise to take on contractually promise to take on the responsibility of any claims made by any third party against you. That needs to be considered in light of what's an insurable risk and what's not an insurable risk. So we'll often work closely with insurers and insurance advisors to say, okay, well, this risk is insurable, so we'll happily take that one on. This one's not insurable, so we won't take that one on. And there's often some argy-bargy in relation to, do you provide an indemnity at all? What's included within the indemnity? And what do you say, no, we're not giving you an indemnity because you've got rights which would otherwise exist at common law, depending on the jurisdiction you're in, without the benefit of an additional contractual indemnity. So so often the senior management are very interested in what the indemnity and liability positions are, as well as what the IP ownership and what you can and can't do with the materials that are being created.
Okay, so that really gets us nicely into the discussion that I really want to focus on today. So I'm in content marketing. I'm working for Air Services Australia. I want to stand up a program of video, audio, stills, text and graphics. I want to be able to use offline channels such as events and advertising, public relations, produce some collateral. I also want to publish on my channels, my website, my social channels as well. But I also want to distribute some of my content on related third-party channels who also have my audience. So I want to present this to you. What are the sorts of questions that are going through your mind that I need to make sure I've got answered in my proposal to you?
Sure. So the first thing to think about that we'd look at is when the content is created, is it created from scratch? And therefore, if it's created from scratch, who owns it? And clarify in writing who owns it. So a trap that a lot of people fall into, they think because I pay for the creation of the intellectual property, that I own the intellectual property that's created. It's one of the often misunderstood areas of IP law. That's not the case. So if you if company A pays you, content group, to develop the material, and they think they own it, they actually don't unless there's an agreement in place with, and you create the content, an agreement in place with you to transfer, and the legal term is assign the IP over to the person who's paying for it. So copyright and profit and sale of a house, for example, are two of the only areas in law that transfer has to be witnessed in writing and signed by the parties. So the first thing is clarify who owns it.
And I have to have something written?
Have to have something written and signed.
Okay, so I've got to make sure that whoever is creating the content for me
Yes.
Is either licensing it to me on terms that I agree to, or is surrendering the rights to me after I have allowed them to produce it on my behalf.
That's right.
I've paid them.
So there's a few areas. So it's looking at who owns the IP which is created, identifying whether there's any IP which is owned by a third party that you need to get a license for, and who you approach for that license. So if you're putting music overlay, for example, in your content marketing, you need to get a license. You can't, of course, just slap that on without getting a license. So you need to either contact the owner of that material, or approach. There are some clearinghouses like APRA, for example, who'll provide you with a
royalty cleared,
a royalty cleared right to use certain music. And likewise, if you're using some graphics or video content, you'll again need to either get an agreement in writing from the owner, or get a license, a collection agency license for a broader scope of being able to use that material. So there's the material which is created from scratch it's not even as straightforward as otherwise. So if the general principle of copyright law is if you're, let's say it's you, content group, if you have an employee who creates the material pursuant to their employment, you automatically own all copyright any other IP which they create, unless there's an agreement to the contrary in writing. If, however, you engage a third-party contractor to develop some material for you, and we're finding in a lot of creative industries these days, someone might engage a subcontractor in India or Russia or wherever to create certain parts of the, let's say, websites, for example, or development of some software. Unless you've got an agreement in place with a contractor, they own it. So you can potentially have a risk if, let's say, if we use you as an example again, you enter into an agreement with a government agency, and the agreement with the government agency says anything that you create for us is going to be owned by us, and you'll transfer ownership of all that IP to us. If you've then got, and you promise that you'll do that, and you indemnify for any claims if you don't, the risk might arise if you haven't connected the dots and shored up the ownership. You can't transfer what you don't own. So you can clearly transfer the IP which your employee has created, but if you've got a contractor who's developed part of that, and you haven't got a written agreement, you can't actually transfer ownership of it because you don't own it.
You don't own it.
And then to muddy the waters even further,
as lawyers like to do,
you may then have a claim that if the materials, the copyright materials were developed collaboratively between multiple parties.
Oh God!
You've then got, and they weren't all your employees. If it was partly developed by the client, partly developed by an employee, partly owned by a contractor, it's a nightmare because you've then got jointly owned IP.
Yeah, but how do you resolve those issues? Like, how do you know?
So you resolve those by identifying them up front. So before you start
here we
working
go. We're going
together,
back to the point of really you've got to be thorough and prepared.
This is back to Kim's very astute point, get the lawyers engaged early.
Yeah.
So before you start working on a project, you would sit down and you'd say, okay, well, this is what we're doing this is the outcome materials we're developing, this is how we're producing it, and this is how we're delivering it.
So just to stop you there, are the lawyers actually interested in the strategic side of things as well?
Generally, because it can provide the context of, so you can help, the lawyers can sometimes then help provide guidance in relation to how you structure the arrangements before you get started. So,
okay.
So
that's a good point.
So the lawyers, let's say you're acting for the government,
Yeah.
And you may have one of your senior execs says, well, we need to own this IP.
Right.
And you've got resistance from, let's say, content groups the other side. And David Pembroke says, no, well, you can't own that because this has got a large part of our template material which we need to modify and adapt and reuse for other clients, and to recreate that would take a lot of time.
Yeah.
So you can actually say to the government lawyer might say, well, do you actually ask the question strategically, do you really need to own this IP, or do you really want to just have a sufficiently broad right to do whatever you want with it, whenever you want, and however you want? So therefore, but you can do all that without owning it. So,
but you do need to shape up that context, though. That's what you're saying, isn't
exactly.
it? To really go into with those discussions to say, here is the policy imperative, or here's the program imperative, or this is what exactly we're trying to achieve.
This is what we want to do with it.
Yeah.
So
and here's the hierarchy, and
exactly.
then cascade it from there.
Exactly. So from the hierarchy in relation to, let's say it's IP, you'd say first question is, who needs to own it?
Yep.
And from there, a lot of decisions will flow. And then once you've identified who needs to own it, you can then say, okay, well, if it's, let's say it's content group on one side of the transaction and a government agency on the other, if the government agency needs to own it, you can then, as content group, say, well, okay, that's fine. You can own this specific part which we're creating specifically for you, and let's call that foreground IP or specifically created IP.
Yep.
You can own that specifically created IP. However, you don't own our background IP.
Right.
But we will give you a license to use our background IP to the extent you need to utilise it to use your specifically created IP. So you can actually then distinguish between different parts of IP in the same content. And so each party, there is a way which you can get a win-win in those sort of scenarios. So, but that again comes down to figuring out strategically what you want to do, why you want to do it, and how you want to do it.
And what other things do you need to talk to the lawyers about? What else do they want to know about?
The lawyers will want to know, for example, are there going to be, let's say we're talking about content marketing.
Yep.
Who is going to be making what sort of statements and promises online in the podcast or in the materials, which recipients might reasonably rely on? So,
okay.
Rely on possibly to their detriment.
To make decisions.
To make decisions. And what happens if the person who's providing the materials or making the statements makes statements which are misleading or deceptive or not accurate? Who's going to carry the can for that if a claim is made? So there's some of the issues which you would need to identify. So we for example act in the non-government capacity, act for a client who regularly has presenters on their television show. And as part of that process, they will ask for an indemnity from the presenter for the making of any claims if they make misleading or deceptive statements or claims or which they know are false. And if claims are made against our client, they would then go back to the presenter who made those statements and say, actually, this one's on your head.
But what if it's just in low risk areas where there's not likely to be any sort of conflict? Do you still are the lawyers still saying no? Well, whether there's low risk or no risk, I do want to see a process that really identifies the risk and a way to mitigate that risk.
No, not really. So it really comes down to lawyers get particularly involved if you do a risk matrix, which we'll sometimes do, and you look at the likely consequences of the risk and the likely occurrence of the risk. And if it's very high risk and it's very high occurrence, or a very high chance it'll occur, we'll of course want to get involved and we'll really want to go a belts and braces approach and put a whole slew of protections in.
Right.
If, however, it's low risk and it's low risk of occurring, we'll probably just say, listen, just be aware of this and maybe just ensure you manage that risk, but we don't need the belts and braces approach. But often there's that sweet spot between the two of it's unlikely to happen, but if it does happen, the consequences are high, or conversely, it it might happen quite often, but it's not a very high risk, but it's still a risk. And then you'd want to ideally cover off the risk, but you don't have to go to town on it.
Now, social media, important channel for content marketers, but given the popularity of it, the growing connectivity, the fact that everyone now owns smartphones and everyone who we need as a government to communicate with are connected, they're on the grid, and they are using these many, many, many different channels and platforms to gather information. What sort of guarantees or what sort of information do I need to put in front of you, again, to enable me to be able to use these channels effectively?
Again, it's the same principles apply. You've also got to, if you're going to be posting something on YouTube, for example, you've got two potential risks. You've got to have a look at pick any social media channel.
Yep.
They will all have their own terms and conditions, which are all different. So some of them might say anything that you post online, this is less likely, but just double check, anything you post on our platform, we'll own the IP to. So you don't want that. More often than not, though, they'll say, you indemnify us from any claims by any third party that what you post online infringes any third party IP rights. So if you post something online which has someone's music on there and you haven't got permission for that, and the music owner makes a claim against you, that platform doesn't want to be liable for that. So that brings us right the way back to making sure that any content you create, irrespective of what your distribution channel is, whether it's on an online platform or otherwise, you want to make sure that you've got the relevant IP ownership covered off and the consent's in place.
Okay. So quite manageable, really, you believe, but again, needs to be addressed, needs to be formally part of a process and needs to be thought through and discussed.
Exactly. And check the terms and conditions of the platform that you're posting on.
Okay. Another area, an increasingly importance in my view, in terms of the distribution of content, is the use of third-party channels. So these are not our channels. These are channels where people have the audience that we're seeking to reach. Say, for example, we're in an agricultural industry.
Yep.
The National Farmers Federation has access to a very large audience. We have a piece of content that we would like to share through their channels in order that we access that audience rather than having to rely on that audience coming to our channel. What are some of the issues around the distribution of content through third-party channels?
So if you're distributing to someone, so you're distributing to someone who, and then allowing them to pass it on to the third party channel. Is that how you?
No, going to the third party and then they distribute it to their audience.
Yeah. So ideally you'd want to have an agreement in place with that third party, which grants them the rights to use your content.
Right.
And it might want to be, for example, do you want to clarify the term in which they're allowed to use it? So can they use it forever, or is it for one episode only, or is it for 12 months? Have they got a geographical restriction on how they use it? And you might have some argy-bargy. The third-party distributor might want to ask you for an indemnity if they get a claim that the content they distribute, which you've provided them, has any claims, and that's probably a reasonable request, but you'd still want to look at that. But you'd also then want to ask for an indemnity from the third-party distributor if they then use your content for purposes beyond the scope of the licence which you've granted to them.
Okay. So really what you're saying is that all of these risks are manageable, all of these permissions are achievable. It's really just about logically working with your legal team to think through what are the steps to put the framework and the architecture for the content marketing program together. Absolutely.
And I think probably the biggest risk issue we've seen, less so in the government context, more in the small to medium business enterprise, is the use of someone who's developing the IP, in this instance, part of the content, but not all of it, using subcontractors and not being fully aware of the risk of not having an agreement in place with the subcontractor.
Yeah, I think that's a good point.
For a discrete part. So we've seen a few issues in the past couple of years where a party has had to contractually transfer ownership of some of the IP to a third party, but they haven't actually been able to because the contractor developed part of it, and the contractors dug their heels in and said, "Oh no, well you paid me to develop it, you didn't pay for a right to own it." And the contractor then who developed that part has then got you over a barrel and can basically ask for whatever they want to allow you to shore up the full title to be able to transfer it, because the risk if you aren't able to then transfer it, you're in breach of your obligation to transfer the IP. So you're really caught in a difficult bind in that sort of situation. But yeah, so the simple way around that is before you get a contractor to develop anything for you, make sure and it has to be it can be a one-pager, a simple agreement in place whereby the contractor agrees that they will assign anything they create over to you on creation.
But on a more broader point, really, what's your view on the fact that there is so much content and information being produced? There are terabytes of information being produced and distributed, and how does the legal system possibly keep up with it all?
Yeah, it's a fascinating point, because what we're finding now is, by virtue of just that very reason, in the old days, if you wanted to copy something, you might have had to get a book out of the library, go down to the photocopier and buy your photocopier card and take a couple of copies, and then you've copied it. And no one's ever really going to find out if you've taken a photocopy of a few pages of a book. The owner of the book's highly unlikely to reach into your briefcase and find it. Whereas these days, it is very easy, with a couple of clicks of a mouse, to copy some content and repost it without authorisation. People do it without thinking about it. We're now finding the IINet case, which has recently come down, is a fascinating one, whereby the judge has actually said that
just give us. We've got quite a big international audience. So
there's a recent case in Australia where the owners of some, I think they might have been the movie houses, took action against Australian internet service provider for allowing or authorising the making of using that internet service to make unauthorised copies of materials, and the movie houses sued IINet for allowing that infringement to take place when they, rather than taking down those sites when people were advised of it. So the judge in the first instance found that IINet wasn't guilty of infringement for allowing those or enabling those infringements. But very recently, the judge has actually given an order to IINet to say, you actually have to deliver up the name and address of every one of your customers so that these people can go directly against the people who are actually doing the infringing activity.
Wow. To
issue claims directly against them. Now, that process has been used a lot in the courts in the USA, and it has been used to almost abused by the content owners, because the judges have been in those jurisdictions have been concerned about just how hard some of the owners of the content have gone in against the little guys. So the compromise which was made in the recent Australian case was, yes, you, the content owners, can request this information from IINet, and you can send demands directly to the IINet customers. However, the letters of demand that you send have to come through the court and the wording has to be approved by us first before you send it, to make it so it's not real heavy bully boy tactics. So
but can they identify the people who are doing the sort of downloading at an industrial level?
Well, they probably could, but this is where it gets fascinating, is if someone was an individual and said, okay, we're suing, they get the letter from the content owner and say, we're suing you because your ISP has identified your internet protocol address as coming from this house and you're on the hook for copying. Yeah. Presumably some defendants will say, well, actually, how do you prove it was me? My home Wi-Fi was unsecure and there's a 50-metre radius around here. It might have been my neighbour, or actually I had bloody Pemby staying with me for that weekend. That bugger's prone for copying stuff, so it was him. So you still got a lot of evidentiary issues to overcome.
Have they tried it yet?
No.
So there's no prosecution being launched yet.
This is all in the last month.
Yeah, right.
So it's all it's all happening. Watch this space, but it's a fascinating area. So but I think the message from that is that some of the bigger content producers are now getting a lot more creative and a lot more stringent in monitoring unauthorised use of their content, and not only monitoring but enforcing their rights.
Okay, so just in summary then, really what you're saying is take Kim Ulrich's advice.
Exactly.
Go to the lawyers and sit with them, present your plan in all its context, in all its glory, in all its detail, and then work with the lawyer through each of the steps as you're talking about.
That's
really,
right.
To then know and understand the permissions that you need to secure at every step of the way. So then when your plan is then going through for approval, it has a sort of legal architecture framework which has been signed off already by the legal team. So as it goes through the executive committees, they say, okay, right, well, this is well prepared, fit for purpose, ready to go. Off you go, and content marketing, knock yourself out.
Absolutely, that's a perfect summary. So I think a roadmap which is agreed by the senior execs, the content producers, and approved by the lawyers is the absolute way to go to develop and create and distribute your content with a very low legal risk.
But the lawyers must love being involved in these productive sort of discussions.
Absolutely. Well, there are different lawyers. There's often you got lawyers who love chasing ambulances. I'm not one of them. There are lawyers who love criminal cases. I'm not one of them. But I just happen to be a lawyer who I love sitting down on these sorts of discussions and working through with creative people and creative content and working through these various sorts of issues. So
because as you step through this discussion here, I just sit here and I've been around for a while, and and you are our lawyer, and I do send things through to you, but I'm probably not as stringent as I need to be, and the processes and the structures that need to be there. And really, as content marketers, we have no excuse. There is no excuse not to be prepared. There is no excuse not to be able to argue your case, to get the budget and the funding, and to be able to engage the resources within the organisation that are there to help you.
That's right.
So there's no excuse anyone out there to really not really put your best foot forward and get prepared, get ready, get in front of it so that you can get to market. Because the other thing in this day and age is speed.
That's right.
We need to be quick. Yeah. We all need to get faster. So,
and I think in a worst case scenario, let's just paint a worst case scenario for if there's an IP infringement claim. So you've gone to you've developed some material, and you've actually quickly gone to market. It's out there, and things are going great. You're getting a lot of hits, and you're getting some great responses. All of a sudden, someone makes a claim against you and says, "Hang on a second, I own that IP." So what might happen? Well, what might happen is the owner of that IP might run off to court and get what's called an interlocutory injunction against you and request an order from the court that you immediately need to take down that content until such time as the dispute is resolved. So you may find a few things. So the content which you've developed for your client or for yourself is immediately taken down, which would be highly embarrassing and highly inconvenient and a cost. You may then, if the matter then goes to full trial, be up for... So the remedies for a breach of infringement of IP, injunction to stop it being used until such time as the court case, because the court case will run for 12 months. So injunction to stop you using it until the court case runs its course. And then if you're unsuccessful at court, the person who brings a claim against you would have two options. They can go for damages against you, and then you can ask if it's a blatant infringement. You can ask for exemplary damages, so a lot more for the flagrancy, or alternatively, you can ask for an account of profits. So you can say, okay, well, you made 200 grand for this, and you used half of ours, so give us 100 grand.
Yeah. Or
not give us 100 grand, ask the judge to make an order for 100,000.
Okay.
But the biggest risk is probably, by the speed purpose, is the risk of it being taken down.
Yeah. because but again, I think the processes are really well identified by you there. The risks are well identified, and really there's no excuse not to really be prepared, have an approach.
Exactly. So
and if you can move quickly, you need to move quickly, but build the relationships as well.
Exactly.
With the lawyers, so as it, to go and buy them a coffee, take them for a lunch, or get to know them a little bit better, so as it, there is that trust and confidence and relationship. So
that's right.
When you say, hey, we've got to move today because that tactical opportunity is upon us,
yes, and
we're going to we really need to move fast. So you've got to have those relationships in place.
Exactly. But so yes, all the doom and gloom, it's all relatively risk-free if you get all your processes in place and your agreements in place up front.
Shaun Creighton, I hope everyone out there got a lot out of that this week. I think there's, it's clear. There is no excuse for us not to be ready with our programs. There's no excuse for us not to go and build those relationships before we need them. There's no excuse not to go and understand what the processes are, to get the templates in place, and to be able to understand what those relationships are with our subcontractors, contractors, other people, and the relationships that they may then have beyond, and expecting that we get some really good quality out of the people who are providing content to us on behalf of our client.
You've been listening to the GovComms podcast. If you enjoyed this episode, be sure to rate and subscribe to stay up to date with our latest episodes.